Good afternoon, everyone, and thank you for joining us for today's webinar. My name is James O'Leary. I'm the Chief Innovation Officer here at Genetic Alliance. Today's titled webinar is The Impact of GDPR on Collecting and Using Data. I'm sure everyone on this call knows that on Friday, May 25th, the European Union General Data Protection Regulation will officially begin to govern the collection, processing, and sharing of personal information relating to EU citizens. And we are very, very lucky to have with us today Dixie Baker. Dixie is a longtime friend of Genetic Alliance who has worked with us in helping to ensure that people's privacy and security are respected and protected while also encouraging participation in research and the power of people to participate. Dixie is a senior partner with Blanck Associates, and she's internationally recognized for her work in health information technology, electronic health records, privacy and security technology, and the sharing and protection of genomic data. She also recently joined as a member of the Interdisciplinary Scientific Working Group of ERDIC and is on a very long list of other committees and roundtables that are relevant to the work that we do. Just a couple housekeeping reminders. Participants are muted during today's call, but you can absolutely type your questions in at any time during the webinar using the questions box on the right-hand side of the webinar panel. We are also recording the session today, and the recording itself and the slides will be available on our website. So with that, I'm going to turn things over to Dixie. Thank you for joining us today.
Okay, thank you for inviting me to talk to you about GDPR today. I do want to clarify from the outset that I'm not an attorney. I'm a technologist, and you know, GDPR is a regulation, and so you know, when you really are seeking compliance, as James well knows, I encourage you to seek the counsel of a GDPR expert, legal expert. So what we'll be covering today, let me see. There we go. We'll go over the basics about what GDPR is all about, the key changes between GDPR and the previous data protection directive that the EU was governed under. The GDPR identifies a number of special categories of information that are particularly relevant to our work, and so we'll talk about those and what the additional requirements on those are. We'll go through the consent conditions and individual elements, and touch on the key differences between HIPAA and GDPR. I know a lot of organizations seek compliance with HIPAA, even if they aren't HIPAA covered entities. And so I think it's useful to look at what the differences are and, you know, what the gap between the two compliance thresholds are. And then finally, we'll go through an exercise at the end to help you ascertain whether you need to become GDPR compliant and whether you want to become GDPR compliant. So the basics are that it does replace the Data Protection Directive, and it aims to harmonize the privacy laws across Europe. Interestingly, although that is what's stated as its objective, it also is effectively harmonizing privacy laws throughout the world. Enforcement begins on Friday. It's a consumer-centric regulation. It focuses on controllers, which are entities that determine the purposes and how data will be used and processed and shared, and processors, which are entities that actually process the personal data on behalf of the controller. It protects the rights of individual European Union citizens regardless of their location, which is why we're concerned about it today. The key changes, the biggest change is the expanded territorial scope. The Data Protection Directive was strictly applied to the EU, and GDPR applies to everybody throughout the world who collects or processes the personal data of EU citizens. It increases the penalties, and it has stronger conditions for consent, both conditions for consent and more elements of consent that must be collected, which we'll cover in a little bit more detail later. The breach notification is within 72 hours, which is quite different from, I think it's 60 days for HIPAA. It adds the right for data subjects to obtain information about whether their data are being processed by that controller and where and for what purposes, and also gives them the right to obtain a copy of that information, which is also a requirement from HIPAA, so that's really not a different one. The right to be forgotten is not only new, but it is very difficult to attain. It gives individuals the right to request that their data be erased. And when the data are erased, that means that they're erased not only in the production system, but that those data are also erased from backup tapes and any place else that the data may reside, and even to reach out to third parties who may have received those data and notify them that the data need to be erased. So that's a difficult one to enforce and to implement. Data portability, which is basically the same as HIPAA's view, download, and transport. Privacy by design, which is a term that came about several years ago, probably 5 years ago, maybe more, out of Canada. And it means that you build privacy into the system from the outset. We've always talked about building security from the outset and how important that is. And privacy design extends that and says you also need to build in privacy from the outset. GDPR requires data protection officers, not for every organization, but for larger organizations. And there are also a couple of requirements that seem to target cloud computing and big data analytics, and I'll point those to you out when we get to them. These special categories of information, Article 9 of the GDPR says that processing of personal data that reveals racial or ethnic origin, political opinions, religious or philosophical beliefs, or trade union memberships, genetic data, biometric data, data concerning health, or data concerning sex life or sexual orientation is prohibited. And obviously what's the most relevant to the most of you and us that are on this call today are that both genetic information and health information are considered special categories of information. The Article 9 says that processing of those are prohibited, and then it proceeds to list some exceptions. And there are two exceptions that I believe are the most relevant to this audience today. First is if the data subject has given explicit consent to process that particular special category of information for defined purposes and defined amount of time. So the GDPR seems to make a distinction between consent, which is required for processing to be lawful, and explicit consent, which is very specific to the data being used, the purposes, period of time, etc. And the other exception that is I think relevant to most of us is that if the processing is necessary for scientific or historical research purposes, and that if the data are used for scientific research, it needs to be proportionate to the aim pursued. You can't use more data than you actually need. Respect the right of data protection, and provide with suitable measures to protect it, to protect the rights of the individuals. Processing of these special categories requires two things. It requires that the processing be lawful, which is Article 6 of the GDPR, and that at least one of those exceptions that are specified in Article 9 apply. So lawfulness in this Article 6 is defined that if the data subject is given consent to processing. And then the only other thing that's in that lawfulness is it makes some exceptions for necessary reasons, just like HIPAA does, contractual and legal compliance, vital interests, public health, etc. The explicit consent is required under three conditions: when the processing is for these special categories of information, when the personal information is used in automated individual decision-making, such as profiling, and third, in data transfers to third countries or international organizations. Now, these last two bullets are those that seem to target cloud computing and big data analytics, because the profiling, that's what big data analytics generally are used, like in Cambridge Analytics or Golden State Killer investigation. This is the people have to be that requires using your data for that kind of profiling type analytics requires the individual's explicit consent. And the other one, the data transfers, all of the reputable and known cloud service providers know about this requirement before GDPR, because there are a number of countries that require that their data not be physically sent outside of their country. So the cloud providers are capable of letting you know that they can keep your data within a country. But if you choose not to do that, then you need to get get the individual's broad consent. So these two requirements really are specific targeting toward these current technologies. And then the consent guidelines seem to be saying that broad consent is sufficient under Article 6 for the lawfulness, but that explicit consent is required for these special categories. Now, there is, in Europe today, there's continuing controversy over the meaning over what GDPR is saying with respect to consent, especially since some of the whereases at the beginning of the law seem to be slightly different from what the law itself says. So there are continuing discussions about consent, but basically consent is required for processing to be lawful, and if you're processing special categories of information, you need more explicit consent. Consent conditions, I'm going to go over both consent conditions and consent elements, and these are basic conditions for consent. Is that the explanation of the processing needs to be very clear, and there needs to be a genuine voluntary opt-in. You know how often you'll see on web pages a little box is already checked, and when you hit continue, that box has already been checked. You don't have to take an action to check it. Well, that's no longer allowed under GDPR. It must be as easy to withdraw consent as it is to give consent, and an organization can't rely on silence or inactivity as consent. You can't say, okay, we're going to use your information for our email distribution unless you object. They have to agree to be on your email distribution. For example, this is an example about the first one is one that we often see, that by signing this, you agree to receive updates from Genetic Alliance. And then you click to sign the petition and you're on the list. But with GDPR, you have to consciously click a box that says explicitly, I'd like to join the campaign and receive updates from Genetic Alliance. And then you sign the petition. So it has to be explicit actions. There are two slides here of the elements of consent that are required to collect information. And interestingly, the consent to process information, the GDPR doesn't go into this detail about the elements required, but the consent to collect the information to begin with, it does go into explicit detail of the elements you have to collect. And you can see it's the identity of the controller, who you remember is the person who actually controls what happens to your information. If there's a data protection officer, the contact for them, what the purposes of processing, the categories of data. Now, the purposes can be multiple purposes for that, for the consent to collect, because it can be a bit broader than for processing special categories. There are some legitimate interests of the controller that data may be needed for, and if that's the case, then the controller has to name what those legitimate interests, why you need to collect this. Like if I need to provide this to our cloud services provider or something like that. The recipients of the data, and where applicable, the controller's plan to transfer data to a third country or international organization. That's the requirement that has implications for the use of cloud computing. How long, the period of time the data will be stored, the right to request correction or erasure. Now, with HIPAA, it has the right to request correction, but it doesn't have the right to request erasure. The right to withdraw your consent or to lodge a complaint, where the personal data came from. And finally, the existence of this, it's always termed in exactly this way, existence of automated decision-making, including profiling, the logic that's involved, and the potential consequences for the subject. So if you plan to use those data to do any kind of profiling of an individual, then you have to let them know exactly what you're doing. These are the next several slides address some of the key differences between HIPAA and GDPR. The first, pardon me, the first is that obviously HIPAA is focused on health data, GDPR is focused on personally identified data of any type, including health. The HIPAA applies to just covered entities and business associates, and those are defined by whether they exchange administrative transactions that are defined in HIPAA. So basically, whether they do billing for services is what it all boils down to. Billing for health services in particular. The GDPR applies to entities that collect or process the personal data of EU citizens. So obviously, it has international applicability and compliance applicability. The consent with HIPAA, it requires patient authorization. In most cases, it implies authorization, but it requires explicit patient authorization for access, use, and exchange other than treatment, payment, and healthcare operations, which are honestly the three primary reasons health information is exchanged, is for treatment, payment, and healthcare operations. Healthcare operations being very, very broad. And there are a few public health and legal and the court order exceptions, which GDPR also has. But GDPR, on the other hand, requires consent for collection and for processing. And there are these few exceptions, but basically, when you collect the data, they have to give their consent. And when you process it for particular reasons, like in scientific research, you again have to have explicit consent. Research, HIPAA allows disclosure of activities for preparatory to research with IRB waiver or the privacy officer, and generally those are given. In GDPR, the use of personal data for research requires consent, and there's no preparatory to research consent exception. So when we're doing identifying cohorts, that is research, so that requires consent. Breach notification is within, as I mentioned earlier, with HIPAA 60 days, with GDPR it's 72 hours, that is a significant difference that will have, very significant ramifications for organizations. De-identification, HIPAA specifies these methods for de-identifying protected health information, either the statistical method or removing the 18 elements that are listed in HIPAA. GDPR excludes anonymized data it's not even included under GDPR. It's the same as de-identified data, but it doesn't specify what is required for anonymization. So it doesn't say, you must do the following things to make sure that your data are anonymized. It just says that if the data are anonymized, GDPR doesn't apply. I think there will be a lot of discussion around that, especially on the international arena, because the term, in my work with Europeans, they commonly use the term anonymized with an S, and they seem to all agree what anonymized data are. But if you ask them what they are, they can't really define it. So I think in Europe, I don't think that they'll blink about that. But outside Europe, I think that people will wonder, what do I need to do to make data anonymized? Special categories, the only special category in HIPAA is psychotherapy notes. It does require individual authorization to use or disclose information, psychotherapy notes, and there are a few treatment, payment, healthcare operations exceptions, but basically that is a special category within HIPAA. In GDPR, there's that long list of special categories that we reviewed earlier, including health and genetic information, and processing of that kind special categories is prohibited without the individual's explicit consent or applicable exception. And the exceptions, they're about, I went over the one for scientific research, and there are others. I think it's B through J are exceptions, but the one that seemed the most applicable here would be the scientific research. Collection authorization is the authorization to collect information is covered in the Notice of Privacy Practices for HIPAA, but the authorization to collect for GDPR requires consent before you can collect the individual's information. The broad versus explicit. In HIPAA, there are no broad consent versus explicit consent. There's just authorization, period. Either it's required or it's not. In GDPR, the consent is required for lawful processing, but then, and that refers to all personal data, and then explicit consent is required for those special categories and special situations that we went over earlier. Oops, was that my last one? Yes. Okay, let's go over to see if you need to comply with GDPR. I want you each to ask yourself each of these questions. Do you have people from the EU on your email list or your mailing list or in your contacts database? And answer to yourself yes or no. Do you have forms that enable users to enter a non-US address or to specify that they're from another country? Answer yes or no. And then finally, do you have purchase or donation forms that allow people to pay using European currency? Yes or no. And then if you answered yes to any one of those, you need to conduct a high-level review of the EU data you hold. I mean, that's the first thing. I wouldn't go and do a detailed data analysis right off bat. I would look at a high level, what are where are the places I might have EU data, or I know I have EU data? And then for yourself, assess whether the value of having those EU data justifies the cost of modifying your systems and your operations to attain the GDPR compliance. And if so, if your answer is yes, I need to have EU data, you should hire an attorney and an implementer with GDPR expertise to help you plan for compliance. You shouldn't just go off and try to do it yourself and then bring in an attorney. It's best at the start to bring in somebody who really understands the law and helps you decide exactly what you need to do and from the outset, and then go do it. And if not, you need to delete all the EU data you hold in your systems and in your backups, and modify all your forms to clarify that you're not soliciting EU customers or participants or contributors. This is not to say EU people can't look at your website. This is to say that you're not seeking their personal information. So with that, let's go into questions.
Okay, great. Thank you very much, Dixie. As a reminder, please use the box for questions on the right-hand side of the screen to submit them. Dixie, I'm going to start with a question. Thank you for this wonderful, informative webinar. A concern we have with compliance is the data erasure. For a patient registry or even a natural history study, if informed consent is removed, the complete erasure of any and all information entered into the database is not necessarily a function of that the database can handle, as it keeps all of the audit trail. Do you have any additional opinion on how to go about handling that kind of situation?
Well, the audit trail, first of all, the audit trail shouldn't be a big deal because you don't keep an audit trail forever anyway. But backups probably are. And there's no question about it that data erasure is one of the more difficult requirements to meet for any organization, because they're used you collect data for a specific purpose, and data can be used for in multiple ways that you may not even be completely conscious that they're used for. So yes, it's a very, very difficult thing to do. I don't think the audit trail should be a problem, but I think tracking down every place the data may be is going to be your biggest challenge. Now, I'm talking about a system audit trail. If you're talking about a more detailed audit, audit of, actions of what happens in the system at a more user level, that would be more challenging.
Okay, great. Thanks, Dixie. And if the asker has any follow-up questions, please feel free to submit them. Another question is, for downstream data holders, do you need to enforce your request that they delete data?
No, you never need to inform. You need to inform them.
Okay.
And, GDPR enforcement it would be in their hands to enforce if they ever did an audit of that organization and they were asked to delete the data and they didn't do it. And you keep a record of who you asked to delete the data as well.
Okay, next question. I have a clinical data collection registry and database with participants worldwide, REDCap online data entry. There are no required elements. The consent explicitly says that. We also explicitly say we share data with other approved studies, some in the US, some in Europe. Where do I need to go with this?
Whoa. Okay. Go read the first part that said elements. That's data elements. There are no required data elements. Is that what you said?
There are no required elements, it says, is the question. I assume data questions for this registry database.
Okay.
Clinical data collection.
Well, did people give their consent to be in this data registry to begin with?
So it does say the consent explicitly says
Okay.
that, and the questioner said yes, they gave consent.
Okay, I think, and I'm not a lawyer, but I think what you need to do is the data that you hold is probably fine because you got their consent to begin with. But GDPR places limits on consent, so it will require you to periodically reconsent people. So I would not panic about what you have, so long as you have the consent. Well, you have the consent to hold it. And if their data are used in any particular research study, you get their explicit consent. Is that correct?
Sorry, Dixie, can you ask that one more time?
You got their consent to collect. And I think
the questioner said not for each study as it stands.
Yeah, you do need the explicit consent for each study where the data are used. You also, I think, if I were you, I would definitely get a lawyer. But I think what they will tell you is that you should plan on reconsenting everybody. And in that reconsent, make sure that you include all the data elements that are required. But in the meantime, you can continue to use the data, but make sure you get their explicit consent for use in a particular study.
So Dixie,
in other words, I don't think you need to throw away your data, but I do think you need to plan to reconsent.
So Dixie, and this is kind of my follow-up question to this, this is obviously a huge issue for many, many researchers who, collect, data with, either broad consent for registries, sample collection with, annotated information, that type of thing. What is the discussion like around this? Is everyone just going, to reconsent? Is there kind of an ongoing discussion in the global community around, what actually has to be reconsented and what doesn't?
No, if you see every one of you go check your email today, and I'll pretty much guarantee that you will have gotten some emails from individuals asking for your reconsent for something. Marriott, I got one from Marriott today that are send out announcements, and they're asking me to reconsent to send me announcements because they realize that's what they're required to do. I don't hear a lot of discussion about that one. And a lot of people hold a lot of data. And I assume this is a data of live people and that you can contact, right? Or else you wouldn't have them.
So, yeah, and I think this is going to get getting a lot of questions, follow-up questions from people, Dixie, which is, reconsent every participant for every secondary use of registry data, and that, essentially this could create some serious problems for all registries worldwide that were essentially built for this purpose and getting broad consent for research trials. So I think this is definitely a major concern for people.
That part, James, is a major concern worldwide. The need to consent for the explicit part, the need to reconsent for just general collection. People are there's not much kicking about that. But for explicit consent, yes, there are professional organizations. I can even send you a link to where the primary conversations are going on. But yes, there is a lot of a conversation about the explicit consent. Now, keep in mind that even the explicit consent for use in studies can be multiple studies. It doesn't have to be one study. You can name, but you have to name the nature of the study.
Right. So, and I do think this is again where legal counsel would be important. People, I think, have different layers of consent. Obviously, if you're a disease-specific organization, I imagine you're initially consenting around research on a disease, which is already more narrow consent. And I think that probably, Dixie, you're not able to comment today on how narrow that has to be.
No, right.
But I would love, actually, if you could share the links to those conversations and we can push those out to the participants in today's webinar.
Well, I would say that the consent is by far the number one topic that's being continually discussed in Europe. And there is, the European Union has issued consent guidelines, but the consent guidelines seem to have just confused people more. But I will send you the link to both the consent guidelines and at least one of the responses, and you'll see the kind of conversations that are going on.
Great, thank you. So next question, if the EU does not list the US as one of the countries that meet GDPR compliance, should we consider implementing Privacy Shield?
I don't know where the conversations are on that. I know we had a safe harbor for the data protection directive. I don't know whether I don't know how likely we are to get one here.
So, and a similar question, someone asked, how do we as rare disease advocates collaborate with EU affiliate organizations if the US is not recognized by the EU as a country that meets GDPR compliance with which those agencies are allowed to share data?
Well, as opposed to the directive, the GDPR is not organization or it's not country oriented. It's more individual. It is completely individual data holder oriented. So I think it would be hard to exempt a country from it because it is individual entity oriented. It's wherever our people's data, and you do have a choice if you choose not to use European Union citizens' data, but it is an entity-oriented thing. And I, as I said before, I don't know where the discussions are right now. I don't even know whether we're looking for an exception. It looks like most organizations are trying to comply.
Right. Okay. Another one that we've gotten a couple related questions on, which is around de-identified data, and that what are the requirements for consent around that type of data?
De-identified data are outside GDPR. They typically, they make it very clear that anonymized data is not addressed in GDPR. And although they don't specify what's required for anonymized data, generally the Europeans recognize U.S. de-identified data as de-identified. I think the exception might be genetic data because our HIPAA has not recognized genetic data as identifiable data or as PHI, and the Europeans don't tend to agree with that.
Right. So another question that has come in is around, and I think you've partially answered this, so I'm going to modify this a little bit. But the question was about an international registry within IRB, HIPAA compliance, informed consent, where no identifying data leaves the registry. And the example they gave is researchers interested in specific patients. They contact those patients, and it is up to them to contact the researchers. Does reconsenting apply to us? So, I think the beginning of that answer is, that's a data processing example. But, this is a registry, for this specific purpose. So where does...
I think the answer that the need to reconsent still applies, the broad consent, not explicit. But I think that the scheme that's there would be a good way to handle the explicit consent because the individual has to contact the researcher.
Okay. And when you say reconsent applies, that would be assuming that they haven't already consented for this specific purpose.
No, the consent, the lawfulness consent, which is what I refer to, and most people refer to as broad consent, that can be multiple, a very wide breadth of purposes. It doesn't have to be, explicit. The explicit is for the use of these special categories, of information.
Okay. So I'm just kind of looking through all these questions, and I do think there is some confusion around when reconsent is needed and what requires reconsent. So meaning, if there was an original consent, what would make that consent valid for this purpose versus...
Well, one thing I probably didn't make as clear as I should have, but remember in the list of data elements for collection, one of them is the time the data will be stored. Even if you got somebody's consent today, you cannot, under GDPR, you can't get anybody's consent indefinitely. The requirement to reconsent is whether you get their consent today or you got it 6 months ago or a year ago. No consent is indefinite. There are time limits on consent.
Dixie, I was at an ISBR meeting, which is an international, for those listeners, it's an international biobanking group presenting around issues like this, but mostly about working with advocacy organizations and communities. One of the things that came up was around data that is collected, especially for individuals that the example that was given at the meeting was around pediatric cancer patients, giving consent for the use of data and samples going forward, and where obviously many of the consenting details are complicated. It's the parent versus the child consenting. If the child is no longer alive, how does that impact it? How do issues impact it when the child reaches an age of adulthood? That type of thing. Is that type of nuance, included in the consent guidelines?
Well, in the GDPR, there are some exceptions for children. It's definitely aiming to especially protect children. There are lots of a number of places in the GDPR that says, especially if children are involved. So there are special protections for children. Now, as far as the information that was collected and the person is, and biobanks, they don't address biobanks explicitly either.
Dixie, another question that might be a little bit more simple is, we are a patient advocacy group and have families from EU in our database. Do we need to reconsent them to receive emails from us?
Yes. And that doesn't mean, I think, and this is my opinion, I'm sure you need to reconsent them at some point. Now, when you need, how long EU enforcement, I doubt that they'll come right at advocacy groups right off bat, but I would start planning to reconsent them, especially the ones in Europe. Yeah. The other point that some of the materials point out that I didn't point out today is that in those last two slides about whether you want to comply with GDPR or not, it's possible to make your organization comply with GDPR for your EU individuals and not for anybody else. I mean, like if you have this huge database of people and only 20 of them are EU citizens, go and reconsent them. You can, bifurcate your data to make sure that your EU citizens, that you comply with GDPR for EU citizens, but you don't necessarily have to do the same thing with everybody. So that's a possibility as well. Even with forms, your technology can detect whether somebody's in the U.S. or not. So you can do that. In fact, most organizations will probably do that.
Okay, if anyone has any additional questions, or you feel like I did not, address your question fully, please submit them now on the right-hand side of your screen. So Dixie, while we're waiting, are there any other areas of this regulation with which are kind of undergoing a lot of discussion or perhaps causing a lot of consternation among the broader community?
There's an EU website that I can send you the link to that talks about the areas where most discussion is going on. Make myself a note. But my own opinion is that the most vehement discussions are around consent.
Mm-hmm. Have you seen anything specifically around users who are deceased, or data for participants who are deceased under kind of the old consent guidelines?
I think that's addressed in GDPR, but I'm not sure.
Okay, it looks like we don't have any further questions. Any final thoughts, Dixie?
No, I'm sorry I couldn't answer all of your questions, but I do appreciate your time and listening. And, if you have any further questions, feel free to reach out.
Dixie, thank you so much for joining us today. I think this is a very complicated regulation. How it applies certainly to U.S. organizations is certainly complicated because there's some competing regulations. Just on a broad scale, Genetic Alliance is interested in certainly supporting these conversations. Not only do we host a registry system here and have users that we want to support their research, but we do really want to support this conversation in the broad community. So if there are further webinars that you'd like to hear, particular questions that you have, please send those our way, and we'll do our best to address them. In addition, please check out any future webinars that we have on different topics. We will be, I think, increasing the number of webinars we have around engagement, participation in research, privacy and security, and those types of topics. So I want to thank Dixie again very much, and I want to also thank all of our participants today. We had a great group and a lot of really insightful questions. This webinar will be posted along with slides and some references that Dixie has or will share with us to the website in the next week. Thank you so much for joining us today, and have a nice day.
Thank you.